Call the third case on this morning's docket, case number 115044, State of Kansas v. Fran Andrade Reyes.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Mr. Andrade Reyes. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a case out of Johnson County, direct appeal in a criminal case, and involves a situation where officers in an encounter with my client found cocaine, and Mr. Andrade Reyes was prosecuted and convicted of possession of cocaine and sentenced. This is his direct appeal. The issue in this case, I think, is pretty straightforward. I don't think my colleague and I have a lot of dispute about the facts in this situation. And it's a nice example of when I'm teaching or talking to people that a lot of times when we do Fourth Amendment cases, you do it really, try to do it chronologically, and second by second even sometimes, to decide, what are we talking about at a particular time and what's justified. In this case, two bicycle officers in Johnson County, Lenexa, I think, are doing their job at 12:30 one morning, and they see a car legally parked in an apartment complex parking lot. And they know that this area is a high crime area. There are things like drugs and prostitution going on in this area, and as is their job, they're out doing their job. And so they see people in this car and they decide to go up to it. So far, there's nothing wrong. This is just good police work. This is what officers are supposed to do. They're out making their presence known in the community and checking on things. So then they come up to this car. Officer Nelson comes up to this car and sees my client as the passenger of this car. And she says, there's nothing that they've seen that's illegal about this car. There's nothing illegal about it being parked there. She doesn't see anything about this car that would indicate to her that a crime is going on at that time in that car. Just general patrol. And then she sees and so, again, there's nothing wrong with her coming up to that car. Police officers can walk, as the state mentions, police officers can walk up to me on the street and say, hey, can I talk to you for a minute about whatever? Maybe they want to talk to me about crime. Maybe they want to sell me tickets to the policeman's ball. There's nothing wrong with that. But the officer sees through the window my client, apparently in her estimation, and I accept this as true, that he's nervous and that he's clenching his hands, and that makes her uncomfortable because she's worried that there could be some sort of a weapon or something like that. I don't begrudge her that opinion. It's a dangerous line of work. But then she asks, would you show me your hand and show me what's in your hand? And my client does not choose to do that. And she requests again, would you do that? And finally she says, open your hand. What's in your other hand? And so this is where we have to make this decision of have they crossed the line from something that's a proper voluntary encounter into something where the officer is taking control of the situation, and therefore it becomes, and my client submits to that control, therefore being a seizure. Because if that's the case, the state needs at least reasonable suspicion under Kansas statute and under the Fourth Amendment.
Or officer safety concern. Or concern about officer safety, which seemed to be the district court's focus.
And Your Honor, I think that's right. And I think that's what the district court said. And I think that's the problem here, is we have these conflating of ideas. Somehow that, for example, that officers in general, that there's some sort of officer safety exception to the Fourth Amendment in general. And that's not true. And there's no law to support that. The Court of Appeals in this case decided this case based on State v. Reese, a decision from this court, where this court said when there's otherwise a lawful stop or encounter, that the officer can take steps in furtherance of his or her safety in that case, when the officer had reasonable suspicion in that case, when Reese is coming at the officer's car. But again, the distinction there, and the distinction with other cases, for example, where courts have said, for example, during execution of a warrant, that you may detain some people that we don't have any. Again, there's a situation where officers are acting under their authority under the Fourth Amendment to do some job under that, to take control of a situation, where they have authority to take control of a situation. And they're in there are officer safety concerns that come into play. But the
And so
predicate
you would
to that
distinguish
is,
that from a typical car stop, where we have said in a typical a true car stop, officers have a right to control the situation.
that's right.
But you would say this is not a situation where the officers had a right to control?
That's
for
right, because
officer
this isn't a
safety?
car stop. In Reese and in other situations, the officers have probable cause or reasonable suspicion to believe that they have the right to control that situation.
What about the case the Court of Appeals cited where a voluntary encounter, but the officer asked the individuals to take their hands out of their pockets? And this court said that didn't move that into a seizure situation. How is that different from asking your client to open his hand so that they could determine that there wasn't an officer safety issue?
And I want to be clear that I'm not misstating. You said the court cited in the Court of Appeals opinion said that was appropriate officer safety. Not this court, not the Kansas Supreme Court. And Your Honor, again, I would argue you shouldn't extend the Fourth Amendment like that. You shouldn't extend, or really restrict the Fourth Amendment like that to a situation where an officer who has no authority over the person gets to tell that person what to do. Even under stop and frisk, there's authority to stop. And if there's not authority to stop, the answer is the officer has no authority over that person.
Are you saying? It sounds like you're saying that if your client had opened his hand in the first instance, you wouldn't be here. It was the progression from, hey, will you open your hand, to the command, open your hand.
I'm not conceding that, but I will concede it would be a harder argument for me. That is to say, I concede that an officer can walk up to somebody and say, hey, can I talk to you? And hypothetically, it's a much worse case for me if an officer says, by the way, would you take your hands out of your pockets, or would you open your hand?
Right.
In a kind of folksy way. Can we sum up your argument that the reasonable suspicion has to arise and precede the concern for officer safety, or the acting on a concern for officer safety, versus the concern for officer safety may form the reasonable suspicion? Is that pretty much summing it up?
It's certainly accurate, especially the first part of it.
Okay.
I mean, my argument is that the officers have to have some authority. In this case, it's the formation of reasonable suspicion. It might be other things like execution of search warrant, but there has to be authority of the
Yes,
officer to
okay.
control the situation.
Okay.
And then when that happens, as this court has held and the United States Supreme Court has held, that there may be situations when officer safety dictates now that they have that authority.
But concern for officer safety can't be the reasonable suspicion in this situation.
That's right.
Okay.
And your use of the term control the situation sounds to me like that's mutually exclusive to a voluntary encounter. Is that what you're saying?
I think it's a non sequitur. That's exactly right. It's a non sequitur to say it's a voluntary encounter, but we're in control.
Right.
It's like, I try to think about examples. If a police officer can walk up to my door at my house to ask questions about crime or sell me tickets to policeman's ball. If the police officer walks up to my door and I come to the door behind my door and I say, he says, can I talk to you? And I'm like, yeah, talk to me through the door. And the officer says, you know what? I'm really not comfortable talking to you through the door. Would you open the door so I can see you? I'm like, no, I don't want to. The officer said, well, I'm ordering you to do that because of officer safety. That doesn't make sense, right? There's no way we would reasonably call that a voluntary encounter anymore. And that's what we think is exactly the situation in this case.
I'm sorry, go ahead.
No, you're right.
This began life as a voluntary encounter.
Yes.
And then at what point, in your view, did it turn into involuntary?
When she commanded my client to open his hand.
When it
And he
stopped.
submitted to that authority.
When it stopped being asked and being told?
Yes.
Okay.
The Court of Appeals in this case, I think, again, confuses the situation because they say it doesn't make any difference whether it was a request or a command. And, Your Honors, I think it makes all the difference in the world with regard to a Fourth Amendment analysis, whether this was a request or a command. That's where my analysis is that I don't know if the first one was a request or a command or not, but when a person doesn't comply and the officer continues doing it, and then the third time it wasn't a request, even the officer admits, yeah, I probably told him to do it. That I don't think there's any reasonable construction of that testimony other than that's a command at that point. The Court of Appeals says it doesn't matter. I hope this court thinks it matters.
So you're saying that if you're in a voluntary encounter, that that precludes the circumstance in which the officer has authority to direct the person encountered to do anything.
That's right. It's not a voluntary encounter if the officer has control over you.
And the only way officers under the Fourth Amendment have authority to elevate an encounter past voluntary is reasonable suspicion.
Is reasonable suspicion, which was not present in this case. I mean, I think the circumstances are very similar to Epperson in that regard.
Does that conclude your presentation?
Yes, Your Honor.
Do we have any further questions?
Thank you.
Thank you, counsel.
May it please the court, Sean Minahan for the state. It's paramount in these cases, especially for officers. You know, even when they come and ask questions or you're talking to them, and you know, your safety is the most important thing.
Is it okay if I'm just an officer whose assignment is to patrol what is acknowledged to be a high crime area? For me to just walk up to anybody on the street and do what was done here?
Yes.
Just because I feel threatened walking through the area?
So I guess the counter to that would be...
No, is it okay and how is it okay? Can you explain the analysis of that?
Yeah. The counter to that...
And then you can tell me your other story.
Okay. Well, this kind of the counter to that is it okay for the officer to do his job? That's his job.
To
or
stop
her
people
job.
on the street and
Well,
order them to do things without reasonable suspicion? There's
Are-
no dispute here that there was no reasonable suspicion other than a fear for safety, right?
No,
That's being
there is
defined as-
reasonable suspicion.
And what is that? That they're
Uh,
sitting in a high crime area?
High crime area. The car was parked away from.
So anyone in a high crime area is vulnerable to this sort of police
Well,
interaction?
Justice. I have several factors.
Okay, great.
High crime area, parked by itself, ways away from the apartment complex. It was in a very dark area. 2 people in the car. As the officer was walking up, she saw the passenger, which was the defendant, look back several times, and he seemed nervous. He reached down to the floorboard, and so this is a dark spot that she's walking up to check on this. He had his clenched fist when he was showing up, and she said, I've never seen anything like that before, somebody act that way. Extremely nervous. He had a surprised look on his face, and she actually even testified. And if you look at that decision by the district court judge, he watched the video of this, Defendant's A, and I'm not sure that's in the appellate record or
I
not.
don't think the video is in the
But he says that you can hear it in her voice. I think from the tape she appeared nervous. So he made a finding based upon the video that he got to see that it was clear that she was nervous for her safety. And the officer testified as such.
I don't think anyone's questioning that. But you say all those other things you listed formed reasonable suspicion.
Yeah, and also she saw in his hand that there was a plastic baggie. So, plastic coming out from his hand. I think all of that, including the high crime area, is enough for a reasonable suspicion that a drug deal is going on.
Okay, thank you.
And then for officer safety, it's kind of the same factors apply. You know, dark area, away from everything, 2 people in the car, furtive movements, all of these factors that weigh towards an officer's right to
Can an officer create a safety concern through a voluntary encounter? Can an officer put themselves in harm's way and then claim officer safety in order to conduct a search? That's my question.
Right.
And that may not be the facts here, but But hypothetically, can an officer without any reasonable suspicion put themselves in harm's way and then claim officer safety to search the person?
In a hypothetical situation, that's a hard to answer because it, like all these Fourth Amendment cases, they depend on the facts. The classic case of that, what you're talking about, is the situation where an officer sees something illegal in somebody's yard, and then he uses a ruse to get onto their property to then say, plain view. You can't use ruses like that, but in this case, an officer has a right
But a
to.
voluntary encounter is not a ruse. Your opposing counsel agrees that an officer can walk up to anyone, try to sell them officer ball tickets, do whatever. How you doing today? What's happening?
Right.
Who's winning the ball game over there? I mean, that's not a ruse. And the question is, can they use that voluntary encounter to put themselves into a situation voluntarily that then allows them to claim officer safety to search?
Yes.
If they don't have to be there.
Yeah, I think that they have a right to do their job. And part of that is to check on the welfare of these two people sitting out in the middle of the car. And even Officer Larson testified, that it's not just about investigating these two people for a crime. It's to let them, people in the neighborhood know that we're around. And to also, if something goes down, they'll have that information that, hey, these two people were in the area at the time and may help us.
But there again, and your opposing counsel said distinguished when the officers were doing their job, authorized to do their job. And if they're making a community safety encounter, that's different than a voluntary encounter. The state uses a voluntary encounter as the person's free to leave and we're really not doing our job, we're just having a voluntary encounter. And you're describing circumstances under which the police are doing their job and they're authorized to be where they're doing their job. And I understand that, but is that really a voluntary encounter?
I don't know how it couldn't be. I mean, they have a right to approach people in the street. Officer Larson had a right to stand by the car. A common citizen has that right. That doesn't give some other party the right to attack them. And so I don't think that those are...
Counsel, do you agree with the Court of Appeals statement, I think it's on page 7 of their opinion, that concern for officer safety can make, in certain circumstances, can make the seizure reasonable?
Yes. And that's the Barnes, one of the cases. The case that they cite is Barnes, where the officers thought that two people were casing a store. And so as the officer walks up to the one outside, he says, hey.
But was reasonable suspicion obtained in that case because of the casing of the store? In other words, the way the Court of Appeals phrased it is officers who otherwise don't have reasonable suspicion can arise out of concern for officer safety exclusively in certain circumstances. That's what the Court of Appeals said. I'm wondering if that's a correct statement of the law.
I think those are two separate things. One is officer safety, which is, I should be able to protect myself and keep a situation safe. And the other one has to do with the Fourth Amendment, reasonable suspicion. And those are two different things, I think.
Well, can an officer seize a citizen for no reason other than concerns for officer safety?
That's the heart of it.
Isn't that what happened in Reese? Or he pulled over and the officer said, hey, you need to get back into your car, as he's addressing the other person. And that's what happened in Barnes, where the officer didn't have reasonable suspicion at the time. I think that's what Barnes says. but said, "Hey, take your hands out of your pockets." Neither of those situations they had reasonable suspicion for the defendant, but they
they
still
were-
had some
They
control.
were controlling the scene, right?
Yeah,
They were controlling the scene. I think that's conceded by opposing counsel. If the officer or officers are at a place where they need to control the scene, they can control all the people that are in proximity of the scene.
right.
And that's a little different than what
Well-
we're talking about. If
There was no controlling the scene in Barnes, though. That was the officer walking up to a guy standing outside of a store and talking to him. And I think Barnes court says that, if this isn't, he didn't have reasonable suspicion in that situation. So we can't find that this
In
is a
Barnes,
voluntary.
Wasn't Barnes the casing case?
Yeah.
Okay, so why doesn't the suspicion that they're casing a store?
That's what the court
Support.
found. I'm
and
pretty sure.
This Court of Appeals,
The Barnes court.
yeah.
Found, and so if we don't find that it's a voluntary encounter, then they have to suppress it.
Yeah.
And so there's a situation where he's there was no investigation or however you want to call it, like in Reese. Unless this court has any other questions.
Why wasn't this a seizure immediately when one officer blocks the driver's door, the other officer blocks the passenger door? And we're talking here about a passenger who didn't have any control over the car or the ability to move the car.
Well, I don't think
This
that.
gentleman couldn't have left the scene without knocking the door into the officer, could he?
The doors were closed.
Right, but I'm
He
saying
could've
he had no way of exiting the situation.
Yeah, she could have pulled backwards. She could have reversed.
This was the passenger, had no control over the vehicle.
Well, first of all, Defendants A, I don't think is in the record, and
I'm sorry.
it's Defendants A, which was a video of this, and but I don't think there's any evidence in the record that it would have been Gross, the second person on the defendant's side. So when they walked up, cars pointed into the parking spot. Officer Larson comes in on the driver's side, and then Gross, and I can't remember if she said 2 or 5 seconds later. He was later, seconds wise, because he testified that the defendant was pulling his hand or moving his hand back up when he was approaching, I think. And so it was kind of a staggered approach by both of them, one a few seconds after the other. And I don't think there's any evidence in the record that they blocked the doors for the case. And in fact, I think the district court talked about, made a finding on that they could have backed up and left if they wanted to. Or the defendant could have said, refused to cooperate.
Clarify for me, isn't the defendant in this case the passenger?
Yes. Yeah.
Do we have any further questions? What are you asking us to do, counsel?
Affirm his convictions.
All right. Thank you.
Your Honor, the only point in response to my friend's argument is that I think in Reese, even in Reese, we see the example of Reese was legitimately stopped. The officer was engaged in a traffic stop there. He cast a pretty wide net, and he accidentally caught Reese, even though that wasn't the person he was meaning to stop. But nobody argued that the stop in Reese's case, the stop itself, was a violation of the Fourth Amendment. I mean, the officer was engaged in lawful law enforcement. He happened to stop both cars, so that's an example in my mind of a case where the officer had authority to control the people, and then the circumstances arose, and so this court said officer safety there. But Your Honor and Justice Breyer, I mean, I've been thinking about your question, and I think if you adopt the Barnes philosophy, we no longer have a stop and frisk doctrine, right? We have a voluntary encounter and frisk doctrine. That even in an involuntary encounter, if the state says we have articulable reasons to believe.
Well, as I read Barnes, it's not a seizure case at all. It was a case decided on voluntariness, right?
I think. Well, I'm not going to contest your reading of it, Your Honor.
Well, I might be wrong.
Yeah. But it was cited by the Court of Appeals in this case for this proposition that it doesn't make any difference if we had reason to stop.
It was cited in the portion of the Court of Appeals decision discussing voluntariness.
Yes. And I'm just saying, if you adopt that philosophy, then we don't have to stop and frisk anymore, right? That's not even what it's about. And I don't think anything from the United States Supreme Court justifies that extension.
Counsel, could you take us through the textbook actions by the officer here in order to have justified the conviction? In other words, as far as you're concerned, they are free to be in that parking lot, correct? That's part of their job.
Yes.
Okay, can you take me through and then tell me where things fell apart for them?
Sure. I think to the extent that this is a voluntary encounter, they can go up, and we haven't fleshed out a lot of the questions that Justice Luker was asking about, the nature of it. But certainly in general, can an officer go up to a car and say, hey, would you talk to me for a minute? And the answer is yes. But if the person says no, for example, then I think the officer has to walk away. And in this case, if the officer sees these circumstances during a voluntary encounter and says, I'm getting uncomfortable with this for my own safety, if that's the case, then the officer should be like, you know what, I'm not comfortable with this. I'm going to walk away because this is a voluntary encounter.
And that's, in your view, what the officer should have done on this occasion.
Should have done or made the decision. I've got backup here. Maybe I'll make other arrangement. Maybe it's, hey, you know what? I'm a little uncomfortable if you won't open your hand, so I'm going to walk over here. We're going to call some more backup here, just so you know that. But thanks for your time and walk away. Yeah, that's right.
And let's say the officer does then take your advice and calls for backup. What are they entitled to do at that point?
I mean, I think until something else would happen that would cause there to be some sort of a seizure or a Fourth Amendment issue, I think they can do that. They could continue watching the car to see if they could develop some suspicion.
Given the fact that assault on a law enforcement officer is a crime, why wouldn't an officer's reasonable suspicion that he or she is about to be assaulted form reasonable suspicion for a seizure?
I would be bootstrapping in this idea that it would always be that situation.
Right, and I'm just asking, why is that? What's the error of logic?
Yeah, I think the main error is it has to require something on the part of my client and intent on the part of my client to have done that. And by sort of reading into, just because the officer becomes uncomfortable with the situation, that becomes evidence of a crime in that circumstance.
You're saying that they're actually, the suspicion of an imminent assault was not reasonable in this situation.
I'm saying that they would have to have more facts. Obviously, if during a voluntary encounter,
if somebody reaches for a gun,
pulls out a gun, obviously officers can't be like, well, I'll just think I'll walk away.
I'm going to walk away. Right?
Yeah, but that's not what the facts in this case are at all.
All right. Any further questions? Counsel, what are you asking us to do?
We'd ask you to reverse and remand this with directions to suppress this evidence.
All right. Thank you, counsel.
Thank you.
I thank both of you for your arguments this morning. Court will take this matter under advisement.